Civil rights. The pending Civil Rights Bill is a dangerous grasp for executive power. The bill would give federal officials authority to violate basic rights of all the people, to invade the constitutionally reserved rights of the states, and to give selected groups preferential treatment in the courts of the land, all for the purpose of eliminating racial discrimination. But discrimination is not defined. Hence, the bill enables officialdom to do anything it pleases, ignoring all the constitutional restraints upon the power of the federal government. All banks and lending institutions, all unions, all private businesses, and all owners of real estate would be subject to the whims and regulations of federal bureaucrats using the armed might, the courts, the tax resources of the nation to enforce attitudes and behavior desired by the bureaucrats. In its present form, the Civil Rights Bill would be disastrous to our constitutional system. That is a summary of my report on civil rights. The full report after a message from my sponsor. On June 19, 1963, President Kennedy sent Congress a special message enlarging earlier proposals for civil rights legislation, demanding that Congress stay in session until the requested legislation was passed. Adam Clayton Powell boasts that he helped write the President's message. Powell has been associated with many communist fronts. He has been criminally indicted for income tax frauds. His tours of foreign nightclubs with his secretaries at taxpayers' expense have scandalized the nation, and his hatred of whites has been openly expressed. Yet Powell appears to be bidding for overall leadership of the militant Negro agitation groups, most of which have been infiltrated by communists. On October 2, 1963, a House Judiciary Subcommittee reported a strengthened version of the Kennedy Civil Rights Bill. 5 days after the assassination of President Kennedy, President Johnson urged Congress to pass the Civil Rights Bill as a tribute to the late president. In his State of the Union message, January 1964, President Johnson again urged Congress to give priority to the Kennedy Civil Rights Bill. On January 30, 1964, the House Rules Committee cleared the bill for debate and action in the House. The bill is nothing less than a demand for concentration of absolute power in the executive agencies of the federal government, to use the armed might, the courts, and the tax resources of the nation to enforce whatever action officialdom may deem necessary to eliminate discrimination. The Civil Rights Bill would eliminate state literacy qualifications for voting in all elections by providing that alleged completion of the 6th grade must be taken as presumption of literacy, whether or not the voter applicant can actually read and write. The bill would empower courts to appoint federal referees to supervise all elections in any area where less than 15% of voting-age Negroes are registered to vote, regardless of the known fact that the low registration rate of Negroes, and of whites as well, in all areas of the nation, results not from any attempts to keep them from registering, but from their own apathy and ignorance about voting. In all elections, about as many whites as Negroes habitually refuse to register and vote. The Civil Rights Bill neither expresses concern about nor makes provisions for non-voting whites. This fact alone proves that the bill, touted as an anti-discrimination measure, is discriminatory legislation, designed not to serve the national interest, but to attract political support from a specified racial group. One of the most important powers of state governments is that of setting voter qualifications. No subject was more thoroughly debated during the Constitutional Convention of 1787. When an illiterate, irresponsible individual of any race has as much voice in selecting political officials as an industrious, productive individual, what is to prevent the dregs and drones of society from plundering hard-working and productive citizens? Politicians can fan hatred in low-income groups, telling the masses they are poor because they are oppressed, making them believe that everyone who has something acquired it by evil means, promising to soak the well-to-do with taxes for benefits to the poor in order to redistribute wealth and guarantee that everyone has his fair share. The Founding Fathers, aware of this danger, created a constitutional system in which all, high and low, would be equal before the law, all equally free to lead their own kind of life as long as they did not infringe on the rights of others, all enjoying the same guarantees against tyrannical oppression by their own government. But the Founding Fathers felt that the vote, which in final analysis is the power to set the policies and direct the affairs of the nation, should be restricted to mature individuals who could understand and have some vested interest in the necessity of maintaining a constitutional system. Hence there was demand in the Constitutional Convention of 1787 that the federal government be assigned the role of establishing voter qualifications throughout the Union. All such proposals were based on the fear that individual states might grant the voting right to people not qualified to exercise it. The proposals were defeated because a greater fear pervaded the thinking of the Founding Fathers, fear of creating a federal government so strong that it could destroy state governments and eliminate God-given rights of individuals. Admitting the need for voter qualifications which would keep the power of the ballot out of the hands of irresponsible people, the Founding Fathers felt there was a greater need to leave this basic attribute of sovereignty in the individual states. Hence, any proposal for federal intervention in elections violates the intent, the spirit, and the provisions of the Constitution. At present, suits by Negroes seeking admission to white facilities or seeking elimination of segregation are generally not initiated by the Negro individuals whose rights are allegedly abused, but are initiated in their behalf by racial agitation organizations. But at any rate, the government itself is not permitted to initiate suits on behalf of some individuals against other individuals, or against private organizations, or against state institutions. The Civil Rights Bill, on the contrary, would authorize the Attorney General to initiate legal action in behalf of colored persons. The United States government would use tax money to bear the legal cost for the colored persons. The persons or organizations against whom the government initiated action would bear their own legal expenses under a presumption of guilt. In any system of law founded on principles of freedom, all persons involved in litigation are considered equal before the courts and in the law, and all kinds of litigation are supposed to be of equal importance. The pending Civil Rights Bill would require preferential treatment in federal courts for litigation in behalf of Negroes claiming violations of their constitutional rights. Excuse me. The Civil Rights Bill would enable federal officials to use the tax resources and the power of the whole nation to enforce upon private organizations and state institutions and individuals attitudes and behavior prescribed by federal officialdom. The bill would enable federal agencies to cancel contracts with any firm doing business with the government if the firm does not hire as many Negroes as federal officials think it should hire, or if the firm does not give Negroes the kinds of jobs federal officials think they should have. The bill would authorize federal agencies to withhold grants of tax money to state and local agencies, private or otherwise, for any program, schools, colleges, hospitals, housing, roads, urban renewal, any kind of program, if federal officials determine that any kind of racial discrimination is involved in the program. Yet discrimination is not defined. It means anything federal officials want it to mean. The public does not even dimly realize how far the financial provisions of the Civil Rights Bill would reach. They would reach out to every bank and lending institution which participates in the FHA or other federal home loan program, which participates in the Federal Reserve System, or even in programs of the Federal Deposit Insurance Corporation. If the Civil Rights Bill is enacted in its present form, federal officials can lay a heavy hand upon practically every citizen who builds, buys, sells, or rents a place to live, prescribing conditions under which he may obtain funds to acquire a home, making rules for use of the property after he acquires it. Banks can be forced to implement the edicts of the federal bureaucrats through foreclosures, refusal of loans, blacklisting, evictions. The Equal Accommodations in Public Facilities section of the pending Civil Rights Bill is most dangerous of all. Here is the essence of that section in the language of the late President, quote, I am proposing to guarantee all citizens equal access to the services and facilities of hotels, restaurants, places of amusement, and retail establishments. The proposal would give the persons aggrieved the right to obtain a court order against the offending establishment or persons." End quote. Here is the President's key sentence concerning the authority for federal officialdom, thus to eliminate the private property rights of businessmen. Quote, "The argument that such measures constitute an unconstitutional interference with property rights has been rejected by courts in upholding laws designed to make sure that private property is used in a way consistent with the public interest." End quote. In other words, an American citizen has no right to own and use private property unless he uses it in a way that officialdom considers consistent with the public interest. Today, the demands of racial agitation groups fix official notions of what is consistent with the public interest. Tomorrow it could be something else. Federal officials could order private employers to hire or not hire Catholics, Jews, Presbyterian, Methodists, Mormons, Christian Scientists, atheists. Federal officials could compel private businessmen to do anything officialdom wants on the simple pretext of requiring the use of private property in a way that is consistent with the public interest. Every United States senator and representative should receive millions of letters from Americans of all races demanding rejection of the Civil Rights Bill. Goodbye. God bless you. For the documented text of this broadcast, send 25 cents to Dan Smoot, Dallas 14, Texas, and ask for 442 Civil Rights. 6 copies, $1.